Good afternoon, members of the faculty, students, alumni, friends, distinguished guests. It's a pleasure to welcome you to Georgetown University Law Center as we celebrate the inauguration of the James and Catherine Denny Endowed Chair. I'd like to welcome members of the Law Center's Board of Visitors and our Law Alumni Board, and a special welcome to the friends and family of Jim and Kate Denny and the friends and family of Professor Goldberg. In just a few moments, Associate Dean Vicki Jackson will introduce Steve Goldberg, but we gather not only to recognize Professor Goldberg for his outstanding achievements at the Law Center, but also to recognize and thank Jim and Kate Denny for their remarkable generosity to the Law Center and for all their years of service to Georgetown. Jim is a 1960 graduate of the Law Center. He began his career at Dewey Ballantine, practicing in New York and Paris. Not a bad first gig. He then had a distinguished career at Sears Roebuck as Chief Financial Officer and Vice Chairman, with oversight responsibility for its Allstate Insurance and Coldwell Banker Real Estate units. He also served as Executive Vice President and CFO at J.D. Searle & Company, and as Chairman of Searle's publicly held Pearl Vision Center business, and as Treasurer of the Firestone Tire and Rubber Company. And he's currently the President of Two Rivers LLC, a family investment firm. Jim serves on numerous corporate boards and is currently the lead director on the board of Gilead Sciences, Inc., of which he served as the chairman from 2001 to 2008. Gilead is a biopharmaceutical company whose major product is the leading therapy for the treatment of HIV/AIDS. He's also served as a consultant to the Pentagon and to the World Bank. Jim is a life trustee and a past chairman of Northwestern Memorial Healthcare Corporation and Northwestern Memorial Foundation. He's a member of the board of the Catholic Theological Union, where he and his wife were instrumental in the establishment and funding of a Catholic-Muslim study program. He's a former member of the board of directors of Georgetown University and of St. Benedict's College, and is a life trustee of DePaul University. And he's vice chair of the Finance Council of the Archdiocese of Chicago and a member of the board and chair of the Finance Committee of the Catholic Church Extension Society. Kate Denny has also been active in numerous charitable organizations. She's currently a director and supporter of the newly founded Chicago Jesuit Academy and is a former member of the board of St. Thomas University. She's a graduate of Trinity College, the University of Minnesota, and the Harvard-Radcliffe Program in Business Administration. Jim and Kate, we are extremely grateful for your long and deep support of the Law Center. Will you stand and be recognized, please? I'd now like to invite to the podium Associate Dean and Carmack Waterhouse Professor of Constitutional Law, Vicki Jackson, who will introduce our inaugural Denny Professor, Steve Goldberg.
It's my great privilege today to introduce our colleague, Stephen Goldberg, on the occasion of his inaugural lecture as the James and Catherine Denny Professor of Law. Since Steve is so well known among us, I will only briefly summarize his legal career. I'll spend some time on his scholarly work, and at the end say a bit about what Steve has meant to me and I think Georgetown. Steve is an accomplished and admired academic. He has been a professor here since 1977, teaching constitutional law, administrative law, federal courts, contracts, and his trademark areas of expertise, law and science and law and religion. He has been an associate dean. He has chaired many of our most important committees, including several generations of appointments committee, at least twice head of our tenure committee. He has served as well on the main campus rank and tenure committee. And Steve was also the first recipient, I think, of the Frank Flegel Award for Outstanding Teaching. Steve graduated magna cum laude from Harvard College and received his J.D. from Yale. After clerking for Chief Judge David Bazelon of the U.S. Court of Appeals for the D.C. Circuit, and then for Justice William J. Brennan of the United States Supreme Court, Steve worked in the Office of General Counsel of the Nuclear Regulatory Commission, gaining valuable insights on the interactions of law and science before joining Georgetown in 1977. Now, on scholarship, let me ask, rhetorically only, how many of us routinely have our scholarly work reviewed not only in law journals, but in places like Science magazine or the American Journal of Human Genetics? Not many, I would guess. But Steve Goldberg's work receives attention and acclaim, not only in the legal literature, but in these other disciplines as well. His scholarly work has focused on intersections between law and other disciplines, or some might say faiths. He is a co-author of what I think of as the great Georgetown law casebook on law, science, and medicine that Steve, Judy Arene, and Patricia King originated, I think, in 1984, and that Larry Gostin has since joined. Now, Steve's deep mastery of several disciplines, his ability to synthesize and write clearly and engagingly about them, make him one of the great disciplinary translators in the legal academy. And let me explain. The first intersection Steve explored in a full-length scholarly book was that of law and science. His 1994 book, Culture Clash, Law and Science in America, explored the ways in which law's emphasis on process and procedure and science's emphasis on material progress created disjunctures that worked to the detriment of both law and science and proposed ways of trying to improve those interactions. This 1994 book, Culture Clash, won the Alpha Sigma Nu Book Award for 1994. The second area of intersectionality in which Steve works is law and religion, and that's the focus of two more scholarly books, Seduced by Science, How American Religion Has Lost Its Way, published in 1999, and Bleached Faith, The Tragic Cost When Religion is Forced into the Public Square, which just came out in 2008 with Stanford Press. Now, Seduced by Science brought together three of Steve's scholarly passions: law, science, and religion. It argues that religious groups do not advance their fundamentally religious mission by adopting scientific forms of empirical arguments to press their religious convictions. Seduced by Science was reviewed in Science magazine in a review that also looked at a book by the great Harvard paleontologist and evolutionary biologist Stephen Jay Gould. Our Stephen Goldberg's book, was correctly described there as insightful and penetrating, while the Kirkus Review described this book as making an original and forthright argument that American religion had sold its soul to science. His most recent book, Bleached Faith, is a very powerful argument for the separation of religion from public life, but not so much for the sake of the state as for the sake of religion. By seeking to place religious symbols in the public square, he argues, proponents of religion diminish both religion's power and the transformative nature of spiritual symbols. And although this book is too new to have garnered many reviews, yet the one I have found in the Library Journal calls Bleached Faith brilliantly written, passionately argued, sincerely unbiased, and a clarion call to restrain the billboarding of religion. Steve is not only a translator, though, between these great fields, but a brilliant and inspired and original thinker and advocate of distinctive normative positions. He is one of the most insightful and forceful advocates for the view already described that religion must be separated from the public square in order to preserve what is distinctly and potentially transformatively religious about religion. Steve writes with great understanding about religion, but takes a distinctive position from that which many religiously sincere people do. The argument for the separation of religion from the public sphere for the sake of religion has been, I think, a very influential argument among those who study law and religion, although in recent years, Steve and others who advance this understanding have been maybe rowing a bit against the tide of the court. But Steve's work has the kind of clarity, honesty, logic, and deep mastery that the best legal scholarship has. And these are traits that will keep his work being read and considered for many decades to come. The last point I want to make about Steve's scholarship is the degree to which it responds to some of the most basic and important intellectual and cultural challenges of our time. About 50 or so years ago, C.P. Snow gave a famous lecture on the two cultures. Snow was talking about the increasingly distinctive modes of disciplinary understanding and research in the sciences on the one hand and in the humanities on the other. For Snow, as he described the humanities, the emphasis is on how knowledge is socially constructed. And in science, the emphasis was on the objective existence of facts with truths that can be verified or falsified by research. And Snow argued that the separation or alienation of these two cultures was, in the long run, harmful to society's ability to understand its situation and solve its problems. More recently, a number of writers, including Samuel Huntington, but also writers like Stephen Gill, have described in various terms clashes of civilizations, sometimes characterized in economic terms, have-nots, sometimes in geographic terms, global north and global south, sometimes in religious terms. Steve's life work has been at the intersections of law, science, and religion, working to translate and to transcend misunderstandings and to create new understandings of those relationships that will be helpful to all. As a review of his book Culture Clash in the journal Geometrics in 1995 said, in conclusion, "Our thinking is better because of Steve Goldberg's work." Now, I could say more, but that wouldn't leave me time to say anything about what Steve has meant to me, which I think is emblematic of what Steve has meant to Georgetown and how vital a part of this wonderful legal center Steve has been for over 30 years. Steve Goldberg was my teaching assistant when I entered law school, and he was, I have to say, the brightest academic spot of my first semester. I could understand Steve when he talked. He was supportive and interested in us as students, for reasons unclear to me, and very non-judgmental. He was so kind, and yet there was not an ounce of that sentimentality or patronizing attitude that can make one uncomfortable. He was analytically incredibly clear without trying to impress you, except we were all totally, completely impressed anyway. Maybe these are the reasons that his students here love him so much, why his courses here are always oversubscribed. He has a genuine interest in his students as individuals. He provides great clarity to his students about the law, and he provides intellectual and social support. And I vividly recall Steve and his wife, Missy, having me and other students over to dinner in what struck me then as their very, very grown-up apartment in a lovely evening in what was otherwise a very challenging first semester, a kindness long remembered. Now, in the early 1980s, Steve was my advisor again. I was a young lawyer, and I was thinking about offering a course at Georgetown Law School as an adjunct. And then Dean Bob Potofsky sent Steve to talk with me. Apparently, even before Steve was an associate dean, he was being tasked with institutional responsibilities, such as evaluating potential adjuncts. We had a wonderful lunch. Steve was very enthusiastic about the course and said Georgetown would love to have me. And then, in a very Steve way, he said, "Now, let me ask you as your friend, why do you want to do this?" And I said something like, "Well, I thought I might be interested in teaching law, and I thought it would be fun." And Steve said, "Vicki, you're a litigator." I was then in practice. "You're a litigator. You have a baby at home. You've told me how demanding the pace already is. Why would you want to do this?" And I looked at him. I gave him, I think, a blank stare, and he explained. He said, "You'll have to do the hard work of being a law teacher, and while you will enjoy your students a lot, you will have very little of the great intellectual benefits that come from outside the classroom interactions with your faculty colleagues." So he said, "Think about it." So I thought, and I decided that Steve was right, as usual, and I withdrew my application. So my children and spouse, thank you for that conversation, Steve, which also left me feeling very well disposed towards Georgetown, a place that would have this attitude. After I came to Georgetown a few years later, I cannot tell you how many times I or others I know of have gone to Steve, sometimes in confidence, sometimes not, for advice. He has never, ever let me down. Confidences stay confidential, and I can always count on his candor and his good judgment. Such a person is rare in life. And when that person has a brilliant mind, a scholar's disposition and self-discipline, and the energy and aptitude for accomplishment of a Steve Goldberg, this person is the equivalent of institutional gold, of Georgetown's very own Fort Knox. One more thing I have to mention is the unabashed centrality of family in Steve's life and the impact that his example has had on me and others. Georgetown is distinctive among great law schools in the atmosphere it creates, in which each faculty and staff member, and I hope each student, has the opportunity to experience life in the community as a whole person, as someone who is a scholar and a teacher and a father or mother and a sister or brother and a daughter or son. I have always loved this part of Georgetown, and I know it binds many of us closely to this school. One cannot know Steve Goldberg even a little without knowing how much he loves and takes pride and joy in his wife Missy, his son Joe, his daughter Becky, his daughter-in-law Jacinda, and his son-in-law Cliff, and, most delicious of all, his grandchildren Mara, Eli, and Hyacinth. Children and family are regular topics of conversation with Steve. There is nothing pro forma about his inquiries. He remembers almost as much about my children as I do, possibly sometimes even more. But what Steve has done in the clear delight he takes in his family, in his pleasure in spending time with them, in placing family first and central, was to provide a wonderful model, an assurance that, yes, you can be a good law professor at a wonderful law school and not only have a family, but share your family experiences with your colleagues. Steve, we treasure you. We have all benefited from your presence on the faculty. We look forward to your lecture and to many more years of your superb scholarship, your unique voice on the intersection of law, religion, and science, your splendid teaching, your public spiritedness and trustworthiness and judgment on behalf of your friends, your colleagues, and the law school. It gives me great pleasure to introduce my friend and colleague, Steve Goldberg.
It is now my great honor to confer the James and Catherine Denny Endowed Chair on Professor Stephen P. Goldberg, and to mark the occasion by presenting him with this engraved medal. Thank you. Steve, the podium is yours. Thank
you. Thank you, Alex and Vicki. And thank you, James and Catherine Denny, for your extraordinary generosity. I'm glad so many of you could come. I'm particularly delighted that my son Joe and my daughter Becky are here, and my wife Missy. About 10 days ago, one of my younger colleagues asked me, what's the secret of a happy marriage? And I told him it's simple: marry Missy. Before I turn to the book of Job, I want to say just a few words about how strongly I feel about Georgetown law. I've read a few autobiographies over the years of people who come to Washington, D.C. to make their career. And they have the unfortunate habit of beginning, Washington was a sleepy southern town before I arrived. And I've noticed that law professors often talk the same way. They say, this school I teach at really wasn't much until I joined the faculty. That is most emphatically not my view of Georgetown law. When I joined the faculty in 1977, this law school was a major law school that had been around for over 100 years. Its graduates were much in the newspapers, people like Edward Bennett Williams and John Sirica. It was led by a fabulous dean, Dave McCarthy. The law school has gotten much better since 1977, and I feel like I've just been along for the ride. And that leads me to the one really important thing I want to say today. I owe more to Georgetown law than Georgetown law owes to me, and I hope I never forget that. Let me turn now to the book of Job and to the role of uncertainty in religion and law. I'd like to present some ideas I've been working on and then take questions and comments from you. Written more than 2,500 years ago, the book of Job has had an enormous influence on religion, philosophy, and literature because of its uncompromising story of a blameless man who suffers at God's hands for reasons no ordinary mortal can understand. One reason for the enduring appeal of the book is its universal nature. Job himself is never identified as a member of any religion or tribe or nation. He is simply an everyman who suffers, who never understands why, and yet never loses his faith. The book itself appears in the Hebrew Bible, the Old Testament, and thus is central, of course, in Judaism. But Job is also referenced numerous times in the New Testament, including in the book of Romans and Corinthians. And Job is discussed in the Quran as well, where we learn that inspiration was sent to Abraham, Isaac, Jacob, Jesus, and Job. Let me just briefly retell the story as it appears in the Bible. Job was a prosperous and pious man who was married with many children. God, while talking with a heavenly figure, the heavenly figure is called the adversary in Jewish translations. He's called Satan in the King James Version. In this discussion, God points out how God-fearing Job is. But the adversary says that Job is pious only because things are going well for him. So God gives Satan permission to destroy Job's possessions, to kill his children, and ultimately to afflict Job himself with dreadful boils. Throughout all of these tragedies, Job refuses to curse God, saying instead, "The Lord giveth, and the Lord taketh away. Blessed be the name of the Lord." And saying as well, "Shall we accept good from God and not adversity?" While Job is suffering, he is visited by three friends, Eliphaz, Bildad, and Zophar. They all tell Job that God rewards the just and punishes the wicked. Everyone knows that. Therefore, they say, Job, whether he realizes it or not, must have done something wrong, and he should repent. Now, in modern parlance, we often hear the phrase, the patience of Job. But at this point in the book, he is not patient. He is impatient, he is angry, he is confrontational. He says to his friends, "You are wrong. I have not done anything that's against the rules. There is no reason for my being punished." He demands to know why he is being treated so badly. Finally, God speaks to Job out of the whirlwind and says, "Who is this who darkens counsel with words without knowledge? Now prepare yourself like a man. I shall question you, and you shall answer me. Where were you when I laid the foundations of the earth?" And then God continues with scores of questions. "Have you commanded the morning since days began? Have you seen the doors of the shadows of death?" And so on. God gives no answers of any kind, just questions. Faced by this barrage, Job finally surrenders. "I have uttered what I did not understand," he says, and he repents. God then restores Job's riches and his family. While doing this, God utters the statement that is perhaps the most crucial part of the entire book. And I think this is why Job is so important to modern secular philosophers as well as religious people. Because God explicitly condemns Job's three friends, saying, "My wrath is aroused against you because you have not spoken of me what is right, as my servant Job has." In other words, the message appears to be that any effort by humans to understand God is hopeless. Even the usual explanations and rationalizations of Job's friends, and perhaps many of us, God rewards good and punishes evil, God surely has a plan we can't understand, that's explicitly condemned. That's too bound by human limitations to begin to explain the ways of the Lord. So the book of Job confronts us not only with the famous question of the origin of evil, why do bad things happen to good people? It confronts the broader, even more unsettling possibility that there are vast, crucial things about life in the universe that we will just never begin to comprehend. Needless to say, Job has been a continuing source of study and commentary within religious communities. It's discussed in the Jewish Talmud and by Jewish commentators throughout the years. Maimonides, for example, wrote in the 12th century that while Job is described as a good and faithful man, we are never told that he was a learned man. So Maimonides suggests that maybe Job was being punished because he hadn't studied enough. I have thought of suggesting this to my con law students. If you don't do the reading, you'll get boils. The book of Job has also occasioned a good deal of commentary in the Christian tradition. G.K. Chesterton, for example, in a famous essay, praises the book because in it God routs the human skeptics by propounding a higher skepticism. Chesterton suggests that Job's wounds prefigure those of Jesus and lead us toward the new hope that Jesus provides. But even when you move away from religion, Job's influence in modern, secular, non-religious philosophy is enormous. Obviously, existentialism is deeply shaped by a Jobian view of the inevitable collision when humans confront a remorseless, irrational universe. The references to Job are explicit and frequent in Kierkegaard. They are very close to the surface in Camus. Moving further into modern philosophy, some scholars have seen traces of Job in Wittgenstein's insistence that we must recognize the enormity of what we cannot know and therefore cannot speak of. And just this year, the American philosopher Susan Neiman, in her book Moral Clarity, analyzes the book of Job in an effort to plumb the religious and secular bases of morality. Well, that's philosophy. Job's influence in literature has been equally great. From Moby Dick to Kafka's Trial, Job looms large. And the story of Job itself has been explicitly retold in modern dress by many authors, perhaps most famously in Archibald MacLeish's 1958 play, J.B., which is just a retelling of the story of Job. It won the Pulitzer Prize, and it's been performed again and again right down to the present day. But for my money, the literary passage that best captures the fundamental idea in Job appears in Graham Greene's novel, Brighton Rock. At the end of the book, a young widow confesses to a Catholic priest that her husband, a violent criminal and a Catholic, has committed suicide, and she wonders if damnation is inevitable. The old priest sighs and says, "You cannot conceive, my child, nor can I or anyone, the appalling strangeness of the mercy of God." The appalling strangeness of the mercy of God. That captures one of the most difficult and unsettling things we learn in life. Not only is evil sometimes inexplicable, but the good fortune that we enjoy, the mercy that is shown us, can be just as mysterious and apparently undeserved as well. So you have philosophy, you have literature, you have theology. What happens when we turn to law? Here we find what is to me an astonishing result. There is virtually no engagement with the book of Job. None. Judges don't cite it, lawyers don't talk about it, even law professors rarely mention it in their writings of lectures. Of course, in the natural law tradition, in which law is a branch of theology or philosophy, you will find discussions of Job. Usually you'll find efforts to explain it away. But modern American law does not use natural law discourse typically, and it is remarkable to the extent to which Job is neither praised nor criticized, it's simply ignored. Consider judicial opinions. A Lexis search of all federal and state courts reveals that the book of Job was cited only a handful of times in the last 50 years. Now, you might say, how often does a judge or a court cite any biblical or literary source? The answer is actually quite a bit. You will find more references to the book of Matthew, blessed are the peacemakers, for example, than to Job. But if you really want to see an influential literary source for judicial thinking, I would recommend Alice in Wonderland. I did the search. And there are literally more than 100, these are real statistics, there are more than 100 citations to Alice in Wonderland for every one to the book of Job. Judges love to go through the looking glass. And don't suppose that they're always using Alice to criticize what a party is saying. Far from it. Just a couple of years ago, Justice Souter, in an opinion for the Supreme Court, criminal law case, wrote, "We cannot forget that we ultimately are determining the meaning of the term crime of violence, which is not to deny that the government's definition might be right. Humpty Dumpty used a word to mean just what he chose it to mean, neither more nor less. And legislators, too, are free to do that. Congress can define aggravated felony in an unexpected way. Souter enjoyed writing this. He loved this. Judges and lawyers love to play with ambiguous words, and so they love to cite Lewis Carroll. And by the way, I've read those few cases in which Job is cited, and I can tell you one thing. If the judge compares your client to Job, you are in trouble. The judges, they like playing God. You suffered, you're going to suffer more. Really. Consider a Pennsylvania case I was reading the other day. The opinion begins, and I'm quoting, "The background of this case reads like a page from the book of Job. 5 children were born to George and Bertha Yandrich. The first 3, at the ages of 3, 2, and 8 months, perished tragically in an accident. The 4th child was fatally injured in an automobile accident in which the driver was negligent. Learning of the accident, George Yandrich committed suicide, and that led to this lawsuit for the negligent infliction of emotional distress." But the court concluded the plaintiff's complaint fails under Pennsylvania precedent. As I say, it's almost as if the judge enjoyed playing the role of God. But the big point is that judges almost never mention Job. And the reason, I think, is that if you think about how lawyers and judges talk about the law, you quickly run into a paradox. On the one hand, you could say that in the law, everything seems saturated with uncertainty. Very few legal matters of any complexity are as simple or as clear-cut as 2 + 2 = 4. Lawyers love to say that virtually any case is winnable and virtually any case is losable. Ambiguities of doctrine, disputes over facts, changing social norms, the judge's political leanings, and on, can shape the outcome of a dispute. That's always true, but that proves too much. For what happens in ordinary legal discourse is that an awful lot simply gets converted into day-to-day odds and predictions. Suppose a drug company executive is considering a certain course of action in response to the government's request for documents. And he asks his lawyer if the government could force wider disclosure in a lawsuit. The lawyer might say something like, "Your approach is quite likely to be upheld in court." If pressed, she might even say, "Oh, I put the odds in your favor at something like 10 to 1. Of course, on other facts, the odds might be very different. This is uncertainty, but of a very mundane and manageable and frankly uninteresting sort. It is nothing like the radical lack of knowledge that Job must live with after God speaks out of the whirlwind. To say that the law is uncertain is like saying that we don't know who will win the Academy Award for Best Actor. We play the odds. Eventually we have a result of some kind. Thus, the uncertainty we are quite happy to live with as lawyers is of a very uniform kind. We see it to a greater or lesser extent wherever we look in our professional lives. We deal with it, and life goes on. There is nothing like the abyss that Job peers into, that the philosophers worry about, that Graham Greene writes about. This lack of engagement with the unknown is even more dramatic when we look at judicial decisions. Now, every judge understands at some level that certain cases might be awfully hard to decide correctly, that the best outcome, if you really thought it through, might be shrouded in mystery. But the judge understands as well that not to decide is a decision. There is nowhere to hide. You cannot indulge a taste for the unknown. Suppose, for example, that a congressional statute regulating pornography on the internet takes effect, and it's challenged in court on First Amendment grounds. If the judge literally does nothing, paralyzed perhaps by the great uncertainties involved, the statute remains in effect, and the First Amendment suffers a bit. One side is lost, and the other side is won. So you have to make a decision. So whether she likes it or not, the judge has to plunge into all of the uncertainties, all the odds, and render a decision. One result of this may be that judges, in order to increase the social acceptability of their decisions, write opinions that ring of certainty, making the law seem more clear than it is. Now again, you might say I'm mixing categories. Judge is a profession. Law is a profession. It's not a philosophical stance towards the universe, like religion or philosophy or literature. So we shouldn't expect to see admissions of deep uncertainty. It's just a job. But that lets us off way too easily. Consider another professional group, Scientists. Every great scientist, working scientist, has a sharp sense of what he does not know. There might be faith that eventually matters will become clear, but there often is a sense that we as humans may never figure out certain problems. Isaac Newton wrote, "I do not know what I may appear to the world, but to myself I seem to have been only like a boy playing on the seashore, and diverting myself in now and then finding a smoother pebble or a prettier shell than ordinary, whilst the great ocean of truth lay all undiscovered before me." And these kinds of reflections apply not just to theoretical physics. Even a humble engineering matter like turbulence, which describes the flow of water through a pipe, is in practice so complex that our equations do not fully describe it. That's one reason that we don't know which pipe will break in the winter and when it will happen. On his deathbed, Werner Heisenberg is reported to have said, "When I meet God, I'm going to ask him two questions. First, why relativity? Second, why turbulence? I really believe God will have an answer for the first." My choice of great scientists like Newton and Heisenberg is not random. Observers have long noted that the greater the scientist, the greater his sense of how little he knows. Now, for a judge, a deep sense of the difficulties of your task, a sense that the unknowable shapes your work, is the mark not of greatness, but of mediocrity. Consider Supreme Court Justice Charles Evans Whitaker. He did not lack credentials or legal ability before becoming a justice. He had served on a federal district court and a federal court of appeals before joining the High Court in 1957. As a Supreme Court justice, he worked longer hours than any of his colleagues as he struggled to make his way through the cases, unable, in most instances, to see a clear legal path to the correct answer. Lists of the least effective justices in history invariably include Whitaker, who was so paralyzed by indecision that he literally could not cast a vote in the pivotal case of Baker versus Carr, and who resigned in 1962 after suffering a nervous breakdown. Most judges learn to put uncertainties aside, to march through every case, hard or easy, and take on the professional persona of the law, a persona that abhors the truly unknown. In sum, scientists, like theologians and philosophers and writers, have a sense of the difference between the unknown and the known. They sense that there is a boundary, and when we gaze into the unknown, we feel a sense of awe and humility. The law is more uniform. It's like an unbounded field, rocky in some places, smooth in others, but essentially unmysterious. The law is a source of analysis and probing and odds-making, not a source of wonder. Now, this may not be a problem to be solved. It may be inevitable. But we might want to consider some of the personal costs to those of us in the legal profession. If we do not leaven the day-to-day perspective of the lawyer with other sources of values, we may end up paying a price. A typical stance of the lawyer taught uncertainty and surprise is not one of awe, but rather one of cynicism. And cynicism can wear you down. A lawyer who loses a case might say, well, of course the judge ignored the statute. He used to work for the oil industry or for the public defender's office. And that will get to you after a while. And the characteristic stance of the lawyer toward the legal world is not the humility of a Newton, but the arrogance of a gunfighter. I have trouble imagining a litigator saying, I am like a boy playing on the seashore, whilst the great ocean of truth lay all undiscovered before me. The litigator is more likely to say, I own this jury. Before I take your questions and comments, let me just conclude by saying that I believe, as people, we would be wise to combine legal learning and teaching with humility and care, with the insights from the moral teachings of many disciplines. I am extremely grateful that Georgetown Law has given me a place to think about these things, and of that I am certain. Thank you. floor is open. People can just come up to the mic if they questions, comments, theories, whatever. Yes?
Thank you so much for your talk, Steve. I was wondering if you could give us some insight into the ethical implications of what you've been talking about today.
You mean professional ethics, legal ethics? Yeah. It's an excellent question because on the surface, it would appear to be at the intersection, of philosophy and law. But I think in practice, legal ethics ends up being a branch of law. In other words, there are a series of rules, and you have to apply them. And the lawyer either gets to keep practicing or doesn't. There's nowhere to hide. You might be haunted in the background by some sense of mystery, but you've just got to go forward. And in fact, with judges, I think they have an ethical obligation to decide cases. Indeed, they can be in trouble if they don't pull the trigger on cases. So legal ethics, I think, ends up being a corner of the law and subject to some of these painful realities. Yeah, Les.
Yes. Steve, thank you. I enjoyed enormously your lecture.
Thank you.
But here is my question. We had a pedagogical problem. The students come here, we want to give them knowledge. But we want to lead them to become aware how much they do not know. How do we do that?
Well, that's a terrific question, Les, and partly for the reasons I've indicated. I think because of your background and learning, you're very aware of how much we don't know. And I would say, first of all, not every law professor shares your profound sense of the limits of knowledge. And I know that in your jurisprudential courses, you're able to bring it out with the students. I think, frankly, if you look for the enemy, you'll find that it's us. I think it's more the problem that the professors are unwilling to tell people how little they know or how little they can do. Now, I do think part of our job enables us to move into a broader area. As you know, part of the Jesuit tradition is education of the whole person. And to the extent you can get people thinking about their whole life, and the limits on their life and how they can't do everything in their whole life, I think that's a beautiful way to introduce some of that. I do. Just come up to the microphone if I think that's the way they have it set up.
First, very quickly, Steve, you won't remember this, but when I was very new on the faculty here and we met, this goes to Vicky's point, you asked me a question about whether I was a believer and did I have a spiritual side, and I said I'm not a believer and I'm not quite sure what you count as a spiritual side. And it's interesting that the question has stayed with me for a long time, because recently someone else asked me the question and I had an answer for them, and I thought, I have an answer because of that conversation with Steve. So
thank you.
That proves Vicky's point. My question, my comment is, you described, I think, how law seems to those who encounter it as lawyers, but I think that those who encounter it as clients, and potentially even our students, find it much more mysterious, and they find what you're calling livable uncertainty. The lawyer can live with it, this odds, that odds. They find it excruciating and unbearable and mysterious and like an affliction. And so I mainly wanted to make that observation and ask you, A, what you thought about that, and B, whether is it part of a lawyer's job to soothe the client by minimizing the client's fear of what I think the lawyer does know is uncertainty over time and in any particular case. I don't know how this tribunal is going to rule. Maybe this jury would come my way, maybe not.
Right.
Or is it more the lawyer's responsibility to, on the one hand, to hold the client's hand and be more reassuring, or to really commiserate with the feeling of uncertainty?
Thank you. Let me say, first of all, I do understand that from the point of view of a first-year law student, the way it's first introduced, it does seem very deep and mysterious. In fact, there's a formal analogy with God speaking to Job out of the whirlwind, because I teach Marbury versus Madison on the first day in constitutional law, and the students learn that Marbury can't go to the Supreme Court, and occasionally a student bravely raises his hand and says, could Marbury have sued in a different court? To which I say, federal or state? Would they have jurisdiction? Could they award damages? And the student's thinking, for this I paid $40,000? I mean, you answer a question with a string of questions. But what we teach them in the end, I think, is the sense that while it's not 2 + 2 = 4, it is a question of odds. And I think our students, as they go through law school, that's what they become comfortable with. Your question about a client is a very good one, and I have to think more about that, the relationship to a client. I've been thinking very much in the legal academy. So first of all, thank you, and I want to think more about that. And what ran through my mind as you were talking, and I'll have to talk to you more and learn more about this, but didn't it sound like a doctor? And doctors often say that for therapeutic reasons, they'll say to a client, everything's going to be all right. They may know differently. They may know how uncertain it is, but you get better outcomes if you say everything's going to be right. And that's, as you know, a deep moral question for doctors, and I will think about it more for lawyers and their clients. Thank you.
I was wondering if maybe a more mundane reason why judges don't quote the Book of Job is the fear of giving offense to religion. I mean, a lot of tropes we lawyers have to refer to powerful, irrational, dehumanizing forces like Kafkaesque, and then I guess you're critiquing Stalin, or Alice in Wonderland, and you're critiquing the Queen of Hearts. But if you use Job, you're kind of critiquing God, and that would give pause to.
Well, first of all, a lot of very faithful, God-fearing people think Job is one of the important books of the Bible. I mean, people interpret it in different ways. But I understand your point, and I think Kafka is the perfect point of intersection. The trial, you don't know the charges against you. It's patterned on the Book of Job. And it's worth noting that, of course, Kafka was a lawyer. Unsurprisingly, he practiced administrative law. And when I first read the trial, I'm thinking, they didn't tell the charges against you. That's nothing. We argue ripeness, mootness, primary jurisdiction. We don't even get to the merits, And so that is the point of intersection. But I think it's common ground that you're supposed to criticize Kafka's trial. You're supposed to act like our trials are different. And they are at least more manageable in how we handle the uncertainty.
Steve, I'm wondering if I can ask you to comment on the last chapter of Job and how it might affect your thinking about the law. The last chapter has always puzzled me, and I'm wondering if the book of Job doesn't itself turn away from the very abyss of uncertainty that you described. 2 questions. Job says that he abhors himself and he repents in dust and ashes. If Job hasn't lost his faith, what is this repentance about? Another thing that has always bothered me about the ending is that Job is rewarded at the end. In fact, he receives more than he lost.
Right.
So at the end of the day, we seem to be back to moral certainty. Should the book have stopped before Job repented and before Job was finally rewarded?
Yeah, that's a terrific question. I want to answer at 2 levels. As your question suggests, the final passage in Job, actually along with the beginning passage, the framing story with Satan, doesn't fit well with the rest of the book. And the technical answer, I'll answer 2 levels, is, as you know, perhaps, many believe it was written by a different and later author. So Harold Bloom, for example, who is a great believer in the book of Job, says Job and Shakespeare are the greatest works of literature. He says that Job was written by an incredible genius. The last chapter could have been written by any fool. That's what he literally says. Because and the framing story is an ancient folk tale and doesn't fit well with the rest, and you're quite right to point it out. And in addition, as you may know, as your question suggests, the statement, I repent in dust and ashes, is very difficult to understand. And there's a lot of debate about the translation. The Hebrew word there, nikamti, is sometimes rendered as repent, but some people say, I regret my challenges, meaning it's more of a standoff between God and Job. In other words, okay, I've heard your questions from the whirlwind. I regret that I asked because you're not giving me a very meaningful answer. So that may be more congenial to you, that continuing the story with that kind of standoff between them. And let me just finally say that model, which I think would some readers like yourself would find better, is central in Jack Miles' book, The Story of God, where he argues that the book of Job is the last one written in the Jewish Bible. And he says after the book of Job, there's silence between the Jewish people and God. There's silence because they've had like this standoff. There is no happy ending. So you've put your finger on what is in historical and literary terms a very good place. So I think the profoundness can be rescued, but maybe some of it is our own imposition and really isn't there.
Steve, thank you so much for
Thank you.
That concludes our formal part of our event today. Please join us for a reception in the back, and I'm sure Steve will continue the conversation with all of us. Thank you so much for being here today.
Thank you, Alex.
You get to keep this.
It was a beautiful ceremony. Thank you.